I dealt with that. Then my parents passed. My girlfriend had a stroke. She's bedridden. Dealing with that, and at the same time, I was going through my cancer, so I had to take care of myself and her at the same time. And I was still sober after. And then just the last year or so, they I don't know. I didn't even know I have what I have, what they say. But I was working with the VA and going through the things that I've been going through. I like to think that I was getting better in my thinking, in my stresses, and it just I don't know what happened. You know, they put me on these medications, and they were up. Couldn't find the right. They were just trying to adjust my medication, trying to get it right. I felt like I had to go, had to leave, had to get out of that house, and so I did. The only way I could do that was take that vehicle, because the one with the interlocking device was down. And I was on the side of the road. Wasn't even driving. Well, it's really cold. Car was running. I did what I did. I know it was a mistake. I know with the key being in the ignition, it didn't matter. I don't know, maybe it was a cry for help. I don't know what it was. And here I am today. And I regret doing what I did. Didn't want to hurt anybody. Didn't want to hurt anybody. All I knew is that when they came in the back door, I thought I was being attacked. I didn't hear anybody say they were. I just reacted. That's pretty much all I got to say, Your Honor.
All right, thank you. Mr. Hoover, I did read through the pre-sentence report in this case, so I'm familiar with the circumstances here and your actions in operating a vehicle that you weren't supposed to be operating while you were under the influence. The experience you had with police officers who were responding to a call. Somebody had called this in because they saw you on the side of the road urinating. And
Okay. I don't know if I can say anything about that.
You can say that's not what happened.
Say that may be what they may have saw or think they saw, but that's not what happened. No, I had to change clothes in the vehicle, and I had urinated on myself while I was in the vehicle. I had gotten out of the vehicle to change my clothes.
Okay.
You know, I was not urinating on the side of the road, especially on M32. For heaven's sake.
Somebody saw something that didn't make sense to them, and they called the police about it. That's how the police got there. And you operated that vehicle to that point, right?
Yes.
Okay. So whether you were on the side of the road or not, you drove that vehicle under the influence of alcohol to get it to where you were on the side of the road, right?
Well, that's where I started drinking the alcohol, was when I was on the side of the road. But yes.
Okay. So you drove to that point.
Yes.
You had urinated in your pants, so you
Yes.
pulled over.
Yes,
And that's when you decided to start drinking.
well. Yes,
Does that sound believable to you?
well. No,
If you're-
Your Honor,
if you're in my
I
position-
suppose it doesn't, Your Honor. No, I suppose it doesn't. It sounds reasonable, but
So it sounds to me like, whatever you're doing in terms of treatment, which is good, I'm sure it's got to involve like having some accountability and being honest
absolutely,
about what
Your
you
Honor.
did. And you're standing up here in front of me today, acting like, you're just this guy on the side of the road who made a mistake and drank, and the police just showed up.
I understand, Your
So,
Honor.
I mean,
No, yes, I understand. Yeah, I was there. I did it. Yes, Your Honor.
so yeah, I mean, you gotta, if you're really serious about your treatment and going forward, you need to start being accountable for your own actions and not pretend like it wasn't what it was. So,
Yes,
especially at this point, because it's not going to do you any good. I'm looking at it. I'm a rational person, and I can see when somebody's making something up or trying to act like it didn't happen the way it did.
no,
So let's just be straightforward as we go
absolutely
forward here, because you're going to be on probation here. I'm going to give you the opportunity to be on probation and to avoid significant jail time.
Yes, sir.
Because of the types of things that you have done since this to get a hold of the problem. But if you're going to be successful on probation, it's going to be because you're being straightforward about what you're doing, both with people who are trying to help you, who are here in the courtroom.
Yes. I'm
And
pretty much upfront.
Okay, I'm going to talk now. And with your probation agent, otherwise we're going to be back here and it's not going to be a good result for you, because you're at the point now where you've got a potential prison time. And I know that's not what you want to happen, and it's not what I want to have happen either. But in order to avoid that, you're going to have to comply with the probation. You're going to have to be straightforward with the people who are trying to help you and with your probation agent. Looking at things as a whole, I do think the recommendation is appropriate. I'm going to follow that recommendation generally. I am going to hold some jail time over your head in abeyance. I'm going to explain that in a second. So as to count one, which is operating while intoxicated, the court's going to sentence you to probation for a period of 2 years. I'm going to adopt as the conditions of that probation all the terms and conditions listed in this report. The court is going to order that you serve 30 days in the Otsego County Jail up front. The court's going to order 6 months total, the first 30 days up front. I'm going to hold the remaining 5 months in abeyance to be used at the discretion of the court. So if you comply with your probation, if you do the kind of things that you need to do going forward, you'll never have to serve that additional 5 months. If you do violate your probation, though, the court can impose any or all of that jail time immediately. So that's a significant consequence, and I hope an additional motivation for you to comply with your probation. The court is going to order a crime victims assessment of $130, court costs of $325, attorney fees of $350, $500 fine, OUIL reimbursement testing fee of $200, a DNA testing fee of $60, $68 state cost, and a supervision fee while you're on probation of $30 per month. As to the resisting or obstructing charge, again, 6 months, 30 days up front, credit for 5 days served, the remaining time held in abeyance, probation 2 years, subject to all the terms and conditions listed in the report. As to the operating while in violation of license restriction, $50 state costs. on that charge as well. 30 days in the Otsego County Jail with credit for 5 days served. No time held in advance on that one. All those sentences to be served concurrent to each other. You do have the ability to seek an appeal of this sentence. We're going to provide you with some papers that explain to you what your appellate rights are, as well as how to request a court-appointed attorney to help you with the appeal.
Judge, I'm sorry, I may have missed it. Did you do the $68 state cost on count 2?
He has acknowledged receipt of his appellate rights on tendering that to the court.
Thank you. You are remanded to the custody of the county at this time. Good luck to you going forward, Mr.
Mr. Bowles? Oh, sorry. I gave you a little note.
Your Honor, I think that's my morning.
Yes, thank you. That concludes the court's morning docket. The court will be in recess until 1:30.
All right, let's talk about that. The sentencing hearing for Eric Hoover was about as layered as they come, and Judge George Mertz once again showed his ability to juggle compassion and consequences without missing a beat. Right off the bat, the atmosphere was calm, but there was a definite undercurrent of concern. Mr. Hoover had already acknowledged his wrongdoing earlier, but this continuation gave us a fuller picture of the man behind the case of veteran dealing with physical illness, caretaking duties, and long-standing struggles with alcohol. His statement was raw and meandering, emotionally open but lacking some clarity. He described overwhelming stress, losing his parents, caring for his bedridden partner after her stroke, and his own battle with cancer. There's no doubt he's been through a lot. But when he described the incident that led to his arrest sitting on the side of the road in a vehicle he wasn't supposed to drive, after allegedly urinating on himself and beginning to drink, the story raised eyebrows. And Judge Mertz didn't let it slide. The judge gave him space to speak, but stepped in with a crucial correction. If Mr. Hoover wants to succeed in treatment and probation, honesty has to come first. Mertz calmly pointed out the inconsistencies in the narrative, especially the claim that the drinking began after he had already pulled over. He didn't shame Mr. Hoover, but he made it crystal clear that any chance of rehabilitation hinges on owning up to what actually happened. There was no grandstanding, just a steady, pointed reminder that accountability isn't optional. Judge Mertz even acknowledged that Hoover had made efforts since the incident via treatment, medications, support networks, but stressed that moving forward meant dropping the self-narratives that soften the truth. Now, here's where the court found some middle ground. Hoover was sentenced to 2 years of probation with a suspended 5-month jail term, plus 30 days to serve up front. That's no slap on the wrist, it's a structured opportunity. The judge laid it out plainly. Stay on track with probation and you avoid further jail time. Mess it up, and that 5 months could come down fast. There were also fines, court costs, and supervision fees, but the tone of the sentence was clear. This is a second chance, not an indefinite one. The resisting, obstructing charge and the license restriction violation were handled similarly, jail time imposed, mostly suspended, and all sentences to run concurrently. The courtroom stayed composed throughout, with Mr. Brown doing a steady job as defense counsel, and Judge Mertz ensuring everything was fully explained right down to appellate rights in fine print. All told, this was a powerful example of courtroom realism. No dramatics, no over-the-top scolding, just a judge, a defendant, and a moment of reckoning. Mr. Hoover got a chance to turn the page, but the warning was clear. If the truth doesn't show up, neither will mercy next time. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read everyone.